Hi everyone and welcome to episode 6. The theme of this episode is Greenbelt and there are two recent court decisions that I want to run through. The first is the Supreme Court's decision in Sam Smith, which was handed down on the 5th of February. The question was whether the local planning authority had correctly understood the meaning of the term openness in the NPPF provisions that relate to the Greenbelt. The Court of Appeal had held that the planning officer's advice had been defective in failing to make clear that visual impact was a potentially relevant and potentially significant factor in assessing the effect of proposed development on the openness of the Green Belt. That was in the context of paragraph 90 of the original 2012 NPPF on mineral extraction in the Green Belt. The equivalent provision in the 2019 NPPF is paragraph 146. Lord Carnwath gives the only judgment. He notes that the concept of openness is a good example of a broad policy concept, which can be contrasted with the policy that was in issue in Tesco and Dundee, which was expressed in narrower terms. Openness is, he says, the counterpart of urban sprawl. It is not necessarily a statement about the visual qualities of the land, although in some cases that might be an aspect of the planning judgment that's involved in assessing the effect on openness. It's worth noting that earlier in his judgment he similarly observes that the visual quality of the landscape is not in itself an essential part of the openness for which the Greenbelt is protected. Lord Carnwath goes on to point out that openness does not imply freedom from any form of development. The NPPF indicates that some forms of development might in principle be appropriate and compatible with the concept of openness. As a practical example of all of that, Lord Carnwath explains that a large quarry might not be visually attractive whilst it lasts, but of course minerals can only be extracted where they're found, and the impact is temporary and subject to restoration. As a barrier to urban sprawl, and remember that openness is the counterpart to urban sprawl, a quarry might, in Lord Carnwath's view, be regarded in Greenbelt policy terms as no less effective than a stretch of agricultural land. Lord Carnwath notes the previous decision of the High Court in the Timmins case, in which the judge held not only that there was a clear conceptual distinction between openness and visual impact, but also that it was wrong in principle to arrive at a specific conclusion as to openness by reference to visual impact. Lord Carnwath states that in his view, the Court of Appeal in Turner was right to disapprove Timmins. There was no challenge before the Supreme Court in Sam Smith's to this statement of approach from Turner. However, Lord Carnwath notes that it tells one nothing about how visual effects may or may not be taken into account in other circumstances. I think he means on the specific facts of other cases. In his view, that's for the decision maker to decide as an exercise of their planning judgment. Moving from previous case law authorities to the facts of Sam Smith's argument, which had been upheld by the Court of Appeal, was that the Council had erred in failing to treat the visual impacts of the proposed development as material considerations in assessing the effect on Greenbelt openness. Lord Carnwath summarises the principles that govern the question whether a consideration is a material consideration that must be taken into account by the decision maker. In short, there are two categories of consideration. There are considerations that the decision maker may have regard to, so that if they do, there will be no error of law. And then there are considerations that the decision maker must have regard to, so that if they do not, there will be an error of law. Now, to fall within the latter category of material considerations that must be taken into account, the consideration must be expressly or impliedly identified as such by the relevant statute, or the consideration must be so obviously material that no reasonable decision maker would have failed to take it into account. So, as Lord Carnwath explains, the Supreme Court in Sam Smith's had to consider whether either of the following two potential scenarios were in play. First, were visual impacts expressly or impliedly identified in the 1990 Act or the NPPF as considerations that the decision maker must take into account in assessing the effect on Greenbelt openness? And secondly, and alternatively, on the facts, were the visual impacts so obviously material to the assessment of the effect on Greenbelt openness that the decision maker was required to take them into account? If either of those two scenarios was in play, then the Council was required to take into account visual impacts in assessing the effect on Greenbelt openness. Lord Carnwath concludes that neither scenario is in play in Sam Smith's. In his view, the relevant paragraph of the NPPF neither expressly nor impliedly refers to visual impact as a necessary part of the assessment of openness. The matters relevant to openness in any particular case are a matter of planning judgment for the decision maker. On the facts in Sam Smith's, the relatively limited visual impact that the proposed development would have fell far short of being so obviously material that the officer's failure to address it expressly amounted to an error of law. So to summarise all that, neither the 1990 Act nor paragraph 90 of the 2012 NPPF expressly or impliedly requires the decision maker to take into account visual impact in assessing the effect of a proposed development on greenbelt openness. I should add that whilst Lord Carnwath refers only to paragraph 90 of the 2012 NPPF, there's nothing in the 2019 NPPF that expressly requires the decision maker to do so either, and I can't see any reason why the courts would hold that there is now an implied requirement to that effect. So it's for the decision maker to decide, as an exercise of their planning judgment, how visual impact is to be taken into account in assessing the effect on greenbelt openness. The limit to that is that visual impact must be taken into account if, on the facts of the specific case, it is so obviously material to the assessment of effect on openness that no reasonable decision maker would fail to have regard to it. So that's the decision in Sam Smith's. The next case that I want to discuss is the recent judgment of the High Court in the Compton case, which was handed down by Sir Duncan Ouseley on the 4th of December last year. This was a statutory challenge to the Guildford Borough local plan. The main general issue was whether the local plan inspector had erred in law in his approach to the exceptional circumstances that were required in order to redraw greenbelt boundaries in the borough. I'm not going to go through all of the issues that are addressed in the judgment, but I do want to highlight some of the points that Sir Duncan Ouseley makes about the exceptional circumstances test. First, the concept of exceptional circumstances is not defined. It is deliberately broad and not susceptible to dictionary definition. That's the result of a deliberate policy decision, so that a planning judgment is to be made in all the circumstances of the particular case. Exceptional circumstances is a less demanding test than the very special circumstances test that applies in the development control as opposed to the plan making context. This we already knew from the Luton case. We also knew from the IM Properties case that there is no requirement that greenbelt land be released as a last resort. All that's required is that the circumstances relied on, taken together, rationally fit within the scope of exceptional circumstances. There need not be more than one individual exceptional circumstance, but conversely, exceptional circumstances can be found in the accumulation or combination of circumstances of varying natures. It's not necessary to explain why each factor or the combination of factors is itself exceptional. They don't have to be unlikely to recur in a similar fashion elsewhere. The inspector simply has to spell out what the factors are and reach a judgment as to whether or not they amount to exceptional circumstances. And in Sir Duncan Ouseley's view, there's a limit to the extent to which that judgment can or should be elaborated. Importantly, general planning needs such as ordinary housing are not precluded from the scope of exceptional circumstances. Sir Duncan Ouseley observes that meeting such needs is often part of the judgment that exceptional circumstances exist. The phrase is not limited to some unusual form of housing or to a particular intensity of need. So unmet need is not irrelevant to the existence of exceptional circumstances. It can weigh heavily and even decisively in the analysis. The point is that it is not necessarily sufficient by itself. In terms of a more practical imagining of what that analysis might look like, Sir Duncan Ouseley put it this way: there will almost inevitably be an analysis of the nature and degree of the need, a lighter consideration of why the need cannot be met in locations which are sequentially preferable for such developments, an analysis of the impact on the functioning of the greenbelt and its purpose, and what other advantages the proposed locations released from the greenbelt might bring, for example in terms of a sound spatial distribution strategy. Sir Duncan Ouseley did, however, caution that the analysis of how the issue should be approached that's found in the Calverton case is not exhaustive or a checklist. The point might not matter in any particular case and others might be important, such as the scope for infrastructure to be provided. One point that is more specific to the facts in Compton is that Sir Duncan Ouseley held that once meeting the objectively assessed need is accepted as a strategic level factor contributing to exceptional circumstances, and he saw no problem with that, then it follows that the provision of headroom against slippage and for future-proofing for flexibility to meet changes also contributes to exceptional circumstances. Furthermore, the local plan inspector was not, in his view, required to calculate a spuriously precise headroom figure and then match it with sites. He was entitled to require a buffer of some significance and to treat the total of the allocated sites as creating an appropriate buffer. So the judgment in Compton, in my view, is very helpful in bringing additional clarity to the concept of exceptional circumstances. I should add that the Court of Appeal has recently refused permission to appeal, so the High Court decision looks like the last word on the subject for now. That's everything for this episode. Thanks for tuning in and take care.